Welcome everyone to the fifth session of Fertility Network UK's 2023 LGBTQ+ Pathway to Parenthood course. My name is Claire, my pronouns are she, her, and I work for Fertility Network UK, providing support to people on a fertility journey and leading on our workplace-specific support. Tonight is the fifth session in this 6-week course, which will cover the various options LGBTQ+ people have in creating a family, and each week we will be joined by experts in their fields to focus on one topic. As a reminder, these sessions are being recorded, so you will be able to watch them back as we'll share them on our YouTube channel. And for reassurance, we are only recording the speakers. Please do ask any questions you want on the topic by submitting them in the Q&A channel, and we'll get through as many as we can. So without further ado, let's begin tonight's session on legal implications for modern families. I'm delighted to be joined by Natalie Gamble from NGA Law and Brilliant Beginnings, and I'm pleased to hand over to her now. Welcome, Natalie, and thank you for joining us.
Thank you very much. It's lovely to be here. And I'm just going to try and share my screen because I've got some slides. You can bear with me. Can I just check? Can you see that okay? Brilliant. Fantastic. So yes, my name is Natalie Gamble, and just to explain why I've got kind of two organisations that I'm part of. NGA Law is a solicitor's firm that specialises in fertility and assisted reproduction and creating families in different ways in terms of the legal aspects. And Brilliant Beginnings is a non-profit surrogacy agency, which my business partner and I set up 10 years ago to facilitate surrogacy both here in the UK and overseas with some of the practical aspects of it. So we are kind of officially two separate organisations providing different services, but the team that I manage and that work with me all very much work together, and it's something that we both kind of feed into the expertise with both sides of the work that we do. To give you a little bit of a introduction, I've explained about the two organisations, but NGA Law was the UK's first fertility law firm. We've dealt with many cases that have kind of stretched the boundaries of the law and made new law. And we've also, for a very long time, been very passionate campaigners for LGBT families. So I got into this area of law because I'm a same-sex mum myself. I've got 2 kids. My daughter is now just turned 21. So when we were conceiving her, my wife and I, through a clinic here in the UK, things were very, very different to how they are now. We, in fact, struggled to find a clinic that was willing to treat same-sex couples at that time in the early 2000s. Through my daughter's journey from being a baby to being a fully fledged adult, we've seen the law transform and new rights for same-sex parents. I'm going to talk a bit about some of those. But along the way, we've always kind of campaigned and pushed for law reform in lots of different areas. Brilliant Beginnings, as I said, we set up as a non-profit surrogacy agency. And again, we've been doing lots of active campaigning for law reform through Brilliant Beginnings as well. So how are LGBT+ families conceived? Just give you the kind of spectrum and the kind of broad agenda of what I'm going to talk about from a legal perspective. Obviously, for most families who are identified as being LGBT, they need help from a third party to conceive. So that might be an egg donor, it might be a sperm donor or a surrogate. So there is, more complicated ways of creating families if you're in those categories of parents. And the spectrum of different ways in which LGBT families can be conceived covers a range of different means of family creation. So at one end of the scale, you have sperm donation for, single mums and same-sex couples. It might be with a donor who's unknown, or it might be with a donor who's known and going to be involved. In the middle of the spectrum, you have co-parenting, where people are collaborating and all intending to share a role in that parenting, rather than one of the contributors being kind of not a parent and a bit more of a distance. And then at the other end of the spectrum, you have surrogacy, which is where a woman carries a pregnancy without intending to be a parent of the child that she gives birth to. That is often for male same-sex couples and single dads, but sometimes it's for single mums and female same-sex couples who've got fertility issues as well. And then we also work with transgender parents, and obviously transgender identities adds another layer of complexity kind of on the top of all of this, which I'll talk through as we go through. Let's start off with unknown sperm donation. So typically this is a scenario where parents, one or both of the parents are able to carry a pregnancy and they want to conceive a child, and they want to use sperm from a donor who's not going to be involved as part of their family. The options in practice for this are to look for a donor through a UK fertility clinic, to look through a UK fertility clinic but with sperm imported from a donor from overseas, or to look overseas to a fertility clinic and to go there for treatment. So if you're conceiving with an unknown donor, so you don't know who the donor is at the time that you're creating your family, then it's worth bearing in mind the legal framework in terms of what rights to information you and ultimately your child will have as well. So if you conceive at a licensed clinic in the UK, whether with UK sperm or imported sperm, then that means that you will have certain legal rights to access information about the donor and any other families who've conceived using that donor as well. So there is a thing called the Human Fertilisation and Embryology Authority's Register of Information, and that will record the details of your treatment and the outcome. And with that Register of Information, your child, when they reach the age of 18, will be able to request identifying details about the donor. So if they want to find out more, potentially they want to contact the donor, they'll be able to do that. And that information is kind of safely held on a public register that's not accessible to everyone, but it is kind of protected, if you like. Your child will also have a right to access non-identifying information before they're 18, although in practice, usually that will be shared with you as the parents from the outset, so you can share that with your child a little bit more informally. And then potentially your child can contact other families. So you as the parents, before your child is 18, will be able to ask if there are any other families that conceived with the same donor, and if so, does your child have any genetic half siblings, and are they boys or girls, and what year were they born? Within the UK regulation, there can only be a maximum of 10 families created with each donor. Once your child reaches the age of 18, they will be able to ask for identifying information about any genetic half siblings. Now, that information is not just automatically released, it's only released if that half sibling has also consented. So it's a kind of two-way means of connecting your child with genetic relatives if that's what they want when they're an adult. So I put possible changes on this slide because there has been some discussion about whether these rules need to be made more flexible and need to be changed in the future in light of various technological advances around DNA testing. So it's something to kind of bear in mind. If you don't conceive through a clinic in the UK, so let's say you go to an overseas clinic, or perhaps you conceive with a home donor, then you won't have that kind of legal wrapper, if you like, around the information rights. So it may be more difficult for your child to contact the donor, but it doesn't necessarily mean they won't be able to. I've put here, are anonymous donors really anonymous anymore? And modern genetic DNA testing is meaning that lots of people are able to track down donors in a way that they weren't able to do in the past, and obviously that technology is expected to grow going forward. So in reality, even in theory, anonymous donor is unlikely to be completely anonymous. But I think one of the good things about the UK system is that it does provide a structure for accessing information and potentially contacting a donor in the future, which makes it kind of work in a more structured way for everybody. Known sperm donation is another option. So with this option, you would choose somebody to be a donor. So it might be somebody that you already know, or it might be somebody that you meet for this purpose. But at the time of conception, you would know who that person is. And it's brilliant in terms of children, where there's kind of then no mystery for either them or for you about this kind of donor, this unknown donor, and you might meet them in the future and you don't know what they're going to be like. But I would say, having worked on known donation cases for many years, that while these are brilliant arrangements where everything goes well, they can be absolutely disastrous if things go wrong. And, fundamentally, there's a dispute between the people who've collaborated to create the child. So if you are opting for known donation, you have to bear in mind that there is that ongoing role and relationship that you're going to need to manage. And it's really important to be clear about, if you're using a known donor, is he just a donor? Is he a secondary parent? Is he going to be a role model to your child? What kind of role is he going to have in your child's life? Because kind of setting that foundation at the start really is important to make sure you all want the same thing. Co-parenting is another option, which is again slightly different. I mean, obviously there's a lot of overlap with known donation, but with co-parenting, the idea is that the biological father would be actively much more involved. So he's doing this to become a parent. He's not just donating his sperm and having that more limited role. And sometimes we see arrangements where there are 3 or 4 co-parents all working together. Sometimes the same-sex female couple will work with the same-sex male couple, so that a child has 2 mums and 2 dads, 4 parents. And there are lots of different family structures these days. We also work with people who are in polyamorous relationships where they're all living together, but there are more than 2 parents as well. And the law in the UK at the moment doesn't cope very well with this concept of a child having more than 2 parents. So you end up with some people having different legal status to the others. So I'll talk a bit more about that in a minute. But again, this is a situation where if you're actively kind of planning to raise a child together, that relationship is going to need managing in the long term. So it's important to kind of set those good foundations. What happens if things go wrong? So I guess, you know, as lawyers, we deal with people who are kind of setting things up and getting advice about birth certificates and, you know, putting written donor agreements in place and those kinds of things. But the flip side is we also deal with people where there is a dispute has arisen and the relationship has in some way broken down. And I think it's really important to stress that any person who's had involvement in the child's life, so let's say a known sperm donor, even if legally they're a donor, if they've had that involvement historically, they will in practice be able to make an application to the family court. So you know, you're not protected by the fact that a donor is not on the birth certificate. And the outcomes in those sorts of disputed cases are incredibly variable because everything depends on the facts of the particular case, and you know, the welfare of that particular child. So we've been involved in cases where donors have been given a really full involvement, a bit like a separated father, where they've wanted to be involved and the mums have not wanted that. In other cases, they've been given a much more limited role. So it's just important to be aware that this is why I talk about, you know, managing that relationship and making sure you don't end up in court. How do you set good foundations? I think it's important to understand the law on parenthood, which I'm going to talk you through in a minute. So, you know, who are the legal parents of your child going to be? What's going to go on the birth certificate? I think it's really important to make sure that everybody's expectations are aligned about what you want and what kind of role each of you is going to play. I think in working through that, that's not a kind of quick answer, and you need to take your time to talk through things, you know, over a period of time to really make sure that, you know, this is the right match for you, that you all want the same thing, that you're going to be able to, you know, be in each other's lives and work together in a positive way in the long term. It's a really good idea to put a written agreement in place. So that could be a donation agreement, a co-parenting agreement. We tend to call them preconception agreements, just to keep it a little bit more neutral. And the benefit of the agreement, people often think that you would put an agreement in place in order to say whether the donor is a donor or a parent, but actually it's less about setting up legal status and it's more about using it as a tool to be clear about what your expectations are and to make sure that you've covered all the things that you would include in agreement and you haven't forgotten to talk about anything that might be important. And then after your child is born, it's important to, you know, hold any boundaries that you've set in terms of what everybody's roles will be, and also invest in that good communication and making sure you're dealing with any issues as they arise or any frustrations before they turn into something more difficult. Finally, in terms of that kind of spectrum of options of ways of building a family, there is surrogacy. And as I mentioned, this is about conceiving a child where neither of the parents is able to carry a pregnancy themselves. So it might be a same-sex male couple or a single dad. It might be a transgender woman. It may well be a same-sex female couple or a single mum as well. So there's lots of different people who use surrogacy for different reasons. So if you're thinking of conceiving a child through surrogacy, the key question is to start off with is always going to be, are you going to try and do it here in the UK or are you going to look abroad? And in the UK, there is a shortage of surrogates, which makes it quite a long and uncertain process for finding someone. But about half the UK parents who conceive children through surrogacy each year do manage to make it work in the UK. The other half choose to go overseas, typically to countries where there is a better legal framework and a better mechanism for finding a surrogate. It's worth saying that if someone who doesn't intend to be a parent is carrying the pregnancy, then that creates some quite complex legal issues around parenthood. So you need to kind of manage those a little bit. Then finally, transgender parents, obviously this isn't a way of creating a family, but transgender and non-binary parents will conceive in lots of different ways. So they may be conceiving through, you know, unknown donation, known donation, co-parenting, surrogacy. Very often trans parents are in the kind of bracket of needing that third party to help them conceive a family. But there are also situations in which trans parents are able to conceive without the help of a third party. So for example, a trans man might be able to carry a pregnancy and conceive with a cis male partner, or a trans woman may be able to provide sperm to her partner if they're able to carry a pregnancy. So there are situations in which there aren't third parties involved, but nonetheless the law around donor conception and surrogacy quite often applies. So let's have a look at the legal issues, having kind of given you a flavour of the different types of cases. And so the law around, you know, how parenthood is formed for children that are conceived through assisted reproduction comes from the 1980s. So there's a piece of legislation in 1990 which didn't deal with LGBT families at all, but what it did do is create legal parenthood for different sex couples who were conceiving either through donation or surrogacy. And the whole idea was to kind of keep the integrity of the mum and the dad in that family unit and to enable them to be recognised as legal parents. We then had a major review of that piece of legislation in 2008. And the focus at the time, this is a few years post civil partnership, was very much about equality for same-sex parents. So we had this existing framework for straight couples, and then they added same-sex couples into the existing legislation so that they're treated in exactly the same way. So in some ways that's great, but it also kind of failed to reflect, you know, the diversity of queer families, and there's no provision for those slightly kind of more fluid family situations such as known donation and co-parenting. It's also worth flagging that there is no provision whatsoever for transgender parents, even though this piece of legislation post-dated the Gender Recognition Act. So we had, you know, it was possible to legally change your gender from 2004, but in 2008 they passed law determining parenthood for people who conceive families through assisted reproduction, which completely ignored the existence of transgender parents. What does the law say? So the law says that the person who gives birth and no other is the child's mother. So biology is irrelevant. So if you are a same-sex female couple and you're conceiving through intrapartner IVF, what that means is that motherhood goes with gestation rather than biology. So it's the woman who gives birth who's the mother and not the biological mother. In surrogacy cases, it means that the surrogate is treated as the child's legal mother rather than the intended parent. Second female parents, you can now, a child can have a mother and a father, or it can have a mother and a second female parent. And if somebody is a second female parent, they can be recorded on the UK birth certificate. And that person will then have exactly the same status in law as a father would have. So they will have shared and equal legal status with the mother in terms of financial responsibility for the child, in terms of parental responsibility, so making decisions and so on, and in terms of things like the child's right to inherit from them. So when is a non-birth mother a legal parent? So there's essentially two different scenarios where the law applies to make her a parent. The first is where the parents are married or in a civil partnership at the time of conception. So either at the time of artificial insemination or embryo transfer if it's conception through IVF. So the conception has to be, I've said artificial, the legislation refers to artificial insemination or transfer of an embryo. So essentially it's conception other than through sex. So it covers home insemination, it covers treatment at clinics overseas, as long as it's kind of done as an artificial conception. And unless it's shown that the non-birth mother did not consent. So the birth mother's spouse is presumed to be the legal parent unless you show that she didn't consent to the conception, for example, if they're separated. So there's a broader range of female parents who can be included if the parents are married or in a civil partnership. If the parents are a couple but they're not married or in a civil partnership, and that's at the time of artificial insemination or embryo transfer, then the circumstances in which the second mother is the second female parent are more limited. So in this situation where they're not married, you have to conceive at a fertility clinic in the UK, and you have to sign the right clinic forms prior to conception and make sure that those forms have not been withdrawn. So there have been a whole load of cases in the last 10 years or so involving situations where clinics have, not completed those forms correctly. And as I said, these forms are absolutely critical, and the way the law is worded means that they have to be in place and correctly signed and completed before the embryo transfer or the artificial insemination. So if the clinic makes a mistake with the forms or forgets to ask you to complete them and you get pregnant, it's too late and you can't put them into place retrospectively. So there have been a whole load of cases now, more than 80, in which clinics have got the forms wrong, and the family court has kind of stepped in to solve some of those issues and find some quite creative ways of saying that the person who was intended to be the second female parent is the second female parent and she can go on the birth certificate. But it's obviously quite a painful thing to think that you're a parent and then be told, actually, we didn't sign the forms, and then you have to make a court application. So my advice to anyone who's not married is, if you're conceiving through a UK clinic, please make sure that you sign those forms, make sure they're both signed, they're done correctly, and that is all in place before you have your artificial insemination or embryo transfer. For parents who fall outside the rules, so there will be situations in which a second female parent isn't a legal parent. So particularly if you're not married and if you're conceiving with a known donor at home, or if you're going overseas and having your treatment at a clinic elsewhere. So in these situations, the second parent can't go on the birth certificate initially, but there are things you can do after the birth to secure her status. So you could apply for step-parent adoption, which is quite straightforward, but also quite lengthy. Possibly you may be able to sign an agreement between you, and certainly you can both put wills in place to make sure that you provide some kind of protection, in the interim. So there needs to be a bit of a legal strategy around, what to do if you're not going to have that status automatically. And the flip side of this is the legal status that a donor or a biological father who might be a co-parent is going to have in terms of the child. So if a child has two female parents, they don't have a father. So there are no scenarios in UK law where you have three legal parents. So if the child has two female parents, then the donor is never going to be the legal father. But in other circumstances where the second parent is not a legal parent, then the donor might be the legal father, depending on the circumstances of conception. So if you're conceiving through a clinic, he may be able to give consent to be just a donor, but if you're not conceiving through a clinic, then he will be the father. And that affects his status and rights in terms of whether he can go on the birth certificate, if you want to name him on the birth certificate, whether he has financial responsibility for the child, whether he shares decision-making, parental responsibility with you. So in co-parenting situations, it's something that's really important to plan around and understand what's possible and what you want to achieve as well. So for multi-parent families, the birth mother is always going to be the legal mother. Who the second parent is going to depend on the circumstances. So who's married to who and how you've conceived. So it might be the second female parent who's the other parent, or it might be the biological father who's the legal father. But you're always going to end up with some parents then who have legal status as parents and some parents who don't. So it might be possible to make an application to the court to get some degree of shared responsibility. And you might be able to sign court forms to do that as well, depending on the specifics of your situation. But you're not going to be able to get full legal parenthood for more than two parents as the law stands at the moment. So with co-parenting, we would suggest that you put a written agreement in place to make clear what everybody's roles and status are, and that you all put in place wills as well to cover some of those gaps that will result from not everybody being a legal parent. So in surrogacy cases, and again, just to be absolutely clear, that surrogacy is where the woman who's carrying the pregnancy does not intend to be a parent. Sometimes we've seen cases where sometimes clinics or sometimes female same-sex parents themselves are told that they're conceiving through surrogacy, where actually what they're doing is intra-partner IVF, where they both intend to be parents. That is not a surrogacy situation. A surrogacy situation is where the woman who's carrying the pregnancy does not intend to be a parent. But even though she doesn't intend to be a parent, she will be the legal parent of the child. And if she's married, then her spouse will be the other parent as well, and they will go on the birth certificate. And what happens after the birth is that the intended parent, if it's a single parent, or the intended parents, if it's a couple, then make an application to the family court to become the legal parents. And that's called an application for a parental order. And that parental order will switch parenthood over to them, so that it moves it to the right place. And it triggers the reissue of the birth certificate. So the child has an original birth certificate, and then that birth certificate gets superseded by a new one, which records the right people as the parents. And that court process takes a while after the birth, typically 5 to 12 months, but it is a kind of full legal solution. So in terms of parental orders, when they were originally created in the 90s, it was only different sex married couples that could apply, but other types of families have been added into the kind of eligibility to do that over the years. So same-sex and unmarried couples were able to apply from 2010, and then single parents were added in from 2019, provided that they have a biological connection with the child. So there's various other criteria, and I won't go through all of those in detail. But it's worth flagging that if you have a child through surrogacy, having gone overseas, perhaps to somewhere like America, where surrogacy agreements are recognised and you're then recorded on the birth certificate, UK law still won't recognise the birth certificate from overseas and will treat your surrogate as being the mother. So you still have to go through this parental order process to become the legal parents in the UK, whether your child was born in the UK or somewhere else. So for transgender parents, as I said, the legislation just doesn't provide for transgender parents at all. So we're having to take law that was designed for other circumstances and apply it for parents who have, been through quite often a legal gender transition. And it doesn't really fit very well, and it produces some quite bizarre outcomes. So a couple of years ago, there was a case involving a trans man who was legally male and gave birth to his son, but the court, he fought a kind of a whole legal battle to try and challenge this, but ultimately the ruling was that he had to be registered on the birth certificate as the mother, which is frankly just completely bizarre. But the law isn't consistent on that. It doesn't say we just kind of ignore, we treat you as the sex that you were assigned at birth. It's more complicated than that, because there are cases where trans partners of birth parents can be registered in their correct gender. And if you have a child through surrogacy and you're transgender, then the birth certificate that's produced after a parental order is made always records you as a parent rather than a mother or a father. So the law is not at all joined up and, very specific for trans parents. But one of the things that we're campaigning for is to have better law that includes trans parents properly. So top tips and things to remember: understand how legal parenthood applies in your particular case. I've kind of really cantered through very quickly in terms of all the different scenarios, but it gives you a feel for kind of quite how complicated it is, because we've got one set of rules for lots of different situations. So you need to work out in your particular situation, who are the legal parents of your child going to be, and therefore what is going to go on the birth certificate. What's that going to record? And critically, is there anything that you need to do before you go ahead with trying to conceive? So do you want to get married, for example, because you both want to be on a birth certificate, and if because of the way you're conceiving, that won't be possible unless you do? Do you want to kind of sign clinic forms to make sure they're done correctly if you're not married and you're wanting to nominate the second parent to be a legal parent? Do you want to make sure that your donor has signed consent forms? All these sorts of things, because the way the law works kind of fixes legal parenthood at the time of conception. So you kind of need to know what the law says before you go ahead with conceiving, because you might be able to manage things in a more favourable way if you have that information at the outset. Secondly, I would say set strong foundations. So take your time and think about, what you want your family to look like, who you want to be involved. If there's any kind of collaborative reproduction, you're involving a donor or a co-parent or a surrogate, then it's really important that, everybody is on the same page and that everybody is in agreement. And, putting things in writing can be a really good way of achieving that. Other things you might need to think about: making wills. So the law kind of has some default positions in terms of, what's expected in terms of who somebody might inherit from if people die without a will. But if you are, one of those LGBT families where you're caught between the gaps a little bit, perhaps you've had a child through surrogacy and you're not immediately going to be a parent, perhaps one of you is going to be a parent and one's not. If you die without a will, you can't assume that your child's going to inherit from you. So it's really important to use wills to kind of cover some of those gaps in terms of inheritance rights, and also providing for guardians who would look after your child if anything happens to you. And then planning for anything that you might need to do after the birth. So if you've had a child through surrogacy, you may need to make an application to the court for a parental order. If you're not recognised as a parent but you want to be, you might be looking at making an application for step parent adoption, or possibly signing forms around parental responsibility. So again, it's all about being informed and knowing what it is you need to do so that you get the status that you need as a family. So that's just the final slide with our websites. Both NJ Law and Brilliant Beginnings have knowledge centres on the websites where there is an absolute ton of free information and access to resources and cases and all kinds of other legal stuff as well, and kind of practical information about surrogacy on the Brilliant Beginnings website. So do have a look around if you want to know any more about this, and there's all of our social media and contact details as well if anybody wants to reach out for any advice. So I'm going to stop sharing, and I'm very happy to answer any questions.
Thank you so much, Natalie. That was so much information to absorb. We have had quite a few questions coming in, so if I just run through them with you, if that's okay. The first question we've had in is, my partner is a trans woman and we're using her sperm to go through IVF. Do we need to consider any specific legals, as I think she will go on the birth certificate as the dad?
Yes. God, every situation is different. So cis woman carrying the pregnancy, is that right? And trans woman providing the sperm. So legally biological father, yes.
Yeah.
So yes, I mean she would go on the birth certificate as the father, but I'm always trying to figure out if there's a way of getting, you know, a more favourable position. If you would want her to go on the birth certificate as the second female parent instead of the father, is there a way of achieving that if it's her sperm? I think possibly you could use the Parenthood forms to nominate her to be the second parent. It might be something to, if you want to email me directly, and we'll have a little, because the facts are all in these sorts of cases in terms of the specifics. But yeah, if you're interested in seeing if we can find a way to make it work so you've got a parent title rather than a father title, we can certainly look at that.
Thank you. Yeah, I guess a lot of these cases are just so individual that you just need to sort of look at each case individually and do the best outcome possible. We've had a comment saying, thank you, this is super helpful. To clarify, if there are two mums and a known donor, donation done through a UK clinic, does this mean that there is no risk that they're entitled to be the father in the case that we don't want him to be?
If you don't want him to be, then if you are married, you would be the mother and second legal parent. And if you're not married, you can sign the forms at the clinic to nominate the non-birth mother as the second female parent. And either of those scenarios would knock out the donor from being a legal father. So he won't have that status and he can't be recorded on the birth certificate. But if you do have an ongoing relationship with him and he has involvement with your child, then that doesn't necessarily mean that he would have no legal rights. And I think this is the kind of distinction that's quite a nuanced one. So we were involved in a case back in 2013, which was the first case involving a female couple who were civil partners, and they were both on the birth certificate, and they'd conceived with a known donor who was legally a sperm donor and not the legal father. And there was a dispute about, he wanted to have a lot more involvement than they felt comfortable with, and so they'd said, right, that's it, no more contact. And then he made an application to the court, and the court had to decide whether the fact they were both on the birth certificate and he wasn't on the birth certificate meant that he couldn't even make an application to the court. And the judge said no, because he'd been involved and they'd chosen him to be a known donor and they'd wanted him to have a role in the beginning, that he had a right to have his case heard. Now, he didn't ultimately get the level of contact that he was looking for, but he was allowed to make the application. So I think with any known donation arrangement, even if you set it up in such a way that the donor isn't the legal father, there is always a risk of that, which is why it's so important to make sure that the donor is happy with whatever role you envisage him having, so that you don't end up in that kind of disputed situation.
Thank you. That leads quite nicely onto another question. Someone has asked about if a known donor and two mums end up going to court over a dispute, would the preconception agreement that you talked about be taken seriously by the courts? How binding is it an agreement, and is it a strong legal instrument?
Yeah, so it's not binding at all, but it's part of the context of the case. So, you know, the court will, any family court application will be dealt with on the basis of what the judge thinks is in the best interests of the child. So they're not bound by the agreement, so it's not binding in that sense, but they will take it into account along with all of the other evidence. So if you have a situation where, you know, you've signed an agreement with a donor which has said he just wants to be kind of a limited donor, that you've treated him like that consistently and he's kind of completely gone against it, I think he would really struggle to achieve any kind of massive level of contact. But if you've signed an agreement which has said he just wants to be a donor, but then in practice you've spent 3 years, you know, having him over every other night and he's been really involved and you've called him dad to everybody and he's starting to build a relationship with the child, that's a really different context. So I think how much weight these agreements have just completely depends on the circumstances. But I think if you treat them as a tool to be able to kind of set those strong foundations, I often think they're more useful, not as a, if we go to court, we're going to rely on it, but more as a litmus test of, do we all want the same things here? And are we avoiding a dispute between us because actually the donor's happy with the role we want him to have? Or in the process of talking through what we're going to put in the agreement, does it become clear that actually he wants a lot more than we feel comfortable with? And I've had quite a lot of cases over the years where I've been involved in drafting an agreement and it's become clear that each side doesn't want the same thing. And actually the decision is, this isn't the right match and we're going to walk away. And I actually think that's a really good decision because I know those cases would have ended up being disputed cases if they'd gone ahead.
That's really interesting. Thank you. And I assume that you would recommend that preconception agreements are always overseen by a legal team.
Yeah, I mean, it depends how you want to do it. I think what's really important is that you have that really good, thorough discussion. And I think often being guided by somebody who's experienced in these issues can be really helpful, because so often we have these discussions and people are like, we've spent ages talking about it, we've talked about everything. And I say, oh, have you talked about this? Have you talked about this? Oh, no, we haven't talked about that. So sometimes it's just about having that kind of extra person to be able to kind of validate those discussions. But we work with parents in different ways. So we have a template agreement, for example, that you can buy from us without any other legal advice, which doesn't cost a huge amount. And it's designed to kind of give you those headings and that structure, so you have that conversation yourselves. But we have a kind of more full service where we would sit down with you and talk about it in a lot more detail and help kind of, you know, sense check what you're saying and have you ask the right things and what's he saying, and, you know, give that experienced kind of sounding board as well.
Thank you. And as you mentioned cost, I'm going to bring it up because obviously finances are a huge burden on people going through assisted conception. So can you give an idea of sort of what the legal costs would be to put in something like that together?
Yeah, so I mean, I can just explain our fees are a fixed fee. So we charge £350 plus VAT for the template donor agreement, or £1,350 plus VAT for the template agreement, with a legal advice meeting taking as long as you need and a letter of advice confirming all the legal issues as well.
That's great. Thank you. Okay, so just asking for a bit of clarification here. We've had a question saying, I'm confused as to whether we both, same-sex female couple, can go on the birth certificate if we are married and conceive at home. We've been told previously no, but now it seems like maybe we can.
Yes, you can, as long as you are not conceiving through sex. So if you're conceiving through home insemination and you're married, then you will both be the legal parents and can both go on the birth certificate.
Great, thank you. Do children conceived through anonymous donor at 18 is there support available to them if they were to request information for tracing, or are they just given the information?
That is an excellent question, because the first children that were conceived under this regime of identifiable donors, which started in 2005, are just about to turn 18 at the end of this year. So there's been a bit of a kind of debate going on about how that's actually going to work in practice. And the requests are going to come into the Human Fertilisation and Embryology Authority. But it doesn't seem that they have a kind of, I mean, my information may be slightly out of date, but from the last that I heard, they didn't have much of a kind of strategy as yet as to what support would be available and how that was going to be funded. So I think it's something that, you know, will need to be worked out, but it was kind of seen as a long grass issue for a long time, and now it's kind of caught up with everybody.
Thank you. They've also said thank you very much for a very informative and helpful session.
No problem.
Somebody's asked, can parental orders be changed or entered into at any point in a child's life, or does it have to be from birth?
I don't know if you mean parental orders. Parental orders are a kind of quite specific order that is moving parenthood when you've had a child through surrogacy. Is that?
Oh, I don't know. Are you able to clarify on that, please? Whoever's asked that question, if you could just pop a little bit more information in, that would be great. And we've just got another one. Related question: if we use a known donor sperm through a clinic, would the known donor be completely excluded from parental rights?
So again, I mean, this is similar to the last question. So if your child is going to have 2 female legal parents, which if you're conceiving through a clinic, you can do whether you're married or not married, then the donor will not have any legal status as the father. So he won't have any financial responsibility. He won't have, be able to go on the birth certificate. But potentially, as I've talked about, the court could give him rights if he applied for them if there was a dispute between you.
Thank you. We haven't had any update on the parental order question. I just wondered if you could tell us a little bit more. You mentioned about changes are being considered regarding donor identification. I just wondered if you've got any more information on what sort of changes are being considered.
Yeah, I mean, I think the general feeling is that, I don't think anything has been recommended as yet, but there's been a bit of discussion about whether the rules in terms of accessing the register are a bit too rigid, and whether more information should be available at an earlier stage, or whether there should be, the ability for donors to say, I'm happy for my details to be released at 16 or 10 or whatever, rather than having kind of one system for everybody. So I think it's something that the HFEA and others are consulting on. But the move seems to be towards more openness and more flexibility rather than in the other direction.
Okay, thanks. We've had clarification. So the parental order question, my misunderstanding on terms, but I think changing the father on the certificate to a second parent female, following on from a trans
so
woman
can
and
you
a
shift
cis
it
woman
around
couple.
later?
Yes.
So essentially, no. So the way it works is that at the date the child is conceived, that's the date at which you determine parenthood. So it's not even at birth. You don't have a choice when you go and register the birth of who you put on the birth certificate. It depends on what the position was at the time they were conceived. So that fixes the legal parenthood when the child's born. The only way of shifting things around later then are by applying for adoption. So, let's say, for example, you were an unmarried female couple, you conceived with a known donor at home. The legal parents at birth would be the birth mother and the donor, but the second female parent could then apply for step parent adoption. That would make her a legal parent and it would take away the parenthood of the donor. So you can move it through an adoption process, or if the child was born through surrogacy, through a parental order, but you can't just opt to change things. It's a process that you have to go through, and there's a welfare assessment and social workers and so on. So it's which kind of comes back to what I was saying about get all the information so you set things up in the way you want to set them up at the outset. Otherwise you're going to have all of this to grapple with if you want to change things later.
Okay, I think that answers the question. Thank you very much. We've had another comment saying thank you for a lovely evening. That's it on the open questions at the moment. Has anybody got anything else they would like to ask before we wrap this up this evening? Welcome to put things in the chat or the Q&A. You can even turn your mic on and talk to us if you want to, if you're feeling brave. It looks like that's it for now. If you guys do have any questions following on from this, as Natalie says, you're very welcome to email her and just put things to her if you've got anything else you'd like to know. And we will be sharing this video as well on our YouTube channel, and we'll pop details of how you can get in touch with Natalie on there as well. So I'd just like to say a really big thank you, Natalie. You've been fantastic this evening. And we will see everybody again for our last session next week, where we'll be looking at lived experiences. We've got loads of people coming to talk about their experiences, so it'll be a really worthwhile session next week for the last one of the course. So Brilliant. Thank you very much, everybody. Have a lovely evening.
Good luck to everybody trying to conceive.
Thank you, Natalie. Good night.
Bye.